Hello and good week. I guess it is, right? Because it's Monday. Welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we are here every Monday morning at 10 a.m. Pacific, 1 p.m. Eastern to talk about all things related to, as the show's title says, trusts and estates, probate, all of those issues surrounding what happens with our property when we pass away. And also, how can we as professionals help people deal with this part of their financial lives? So we're here for 30 minutes. And today, our topic is how to avoid probate, right? So you might call this, how to avoid needing to pay people for professional advice, although it doesn't really may not necessarily work out that way. It depends what strategy you're going to use. So let me go ahead and share my screen here. And there we go. Okay, here we are, Trusts and Estates Weekly. So as those of you who are regular viewers know, everything we do on the Way to Wow shows revolves around the three pillars of attainment: self, relationships, and pursuits. And on the shows I do, we're focused primarily on the pursuits pillar in the finances realm, although we do touch on other issues, relationships, and our self-identity, etc. Okay, so that didn't go through. There we go. All right, so before I talk about how to avoid probate, we need to talk about what probate is. Okay, so when someone dies and their property is above a certain level, and that varies from state to state, in order to distribute their assets, their estate, which is the collection of all their property, has to go through a court proceeding called probate. Now, if they have a will, you'll hear the term their will be probated. That's just part of the probate process. So what happens in probate is if the will appoints an executor or an executrix, so you don't hear that term too often, but that's a female executor or a female administrator of a will, we'll call it. Okay, so if there's a will and the executor agrees to handle the estate, so then that person will be appointed to probate the estate. You actually don't probate the will per se, okay, because there are other things that happen in probate besides what the will directs. Now, if that person doesn't want to be the executor or for various reasons cannot be the executor, then the probate court will appoint what's called an administrator. And as you might imagine, a female administrator is known as an administratrix, although again, I don't think you hear that term used. I don't think it's used in any court anymore, but it used to be more common quite some time ago. So I'm going to use executor and administrator interchangeably, even though they're not the same thing. But in any event, the executor is responsible for several things. One is opening the probate. Okay, now if the executor doesn't open, if there is no executor, then a probate will be open and an administrator appointed. Okay, next, that the executor will be responsible for identifying all the property that the deceased owns. Okay, that's the deceased's estate. The executor will also have the responsibility of identifying all outstanding debts. Okay, because part of settling the estate is settling the debts. Okay, now the executor oftentimes will deal with issues of life insurance, etc., although life insurance typically is not part of a probate. It happens outside of probate. But in any event, an executor will oftentimes deal with any claims for life insurance, or if there was some sort of accident insurance and the death was a result of an accident, those kind of things, then the executor will deal with that. And then the executor will see to it that the debts are settled. Notice I didn't say paid, okay? Because some debts may not necessarily need to be paid. They just need to be settled in some way, okay? And then the property remaining will then be distributed. If there's a will, it'll be distributed according to a will. If there's no will, it will be distributed according to the laws of descent and distribution for the state in which the probate is taking place. That's something called intestate succession. Intestate is a Latin term that means essentially without a will. And we're going to talk about that next week, how all that works. It can get kind of complex, okay? But in any case, let's just deal this week in a case where there is a will, and the will says, who gets what property. So the executor sees to it that the property is distributed, and then after everything else is done, including if there's any taxes due, whether it's in filing a final income tax return, whether there's an estate tax return there is an estate tax return that may have to be filed. There may be estate taxes due, although the estates have to be pretty large these days, and at least until I think it's the end of 2025 before that becomes an issue, or was likely to become an issue for smaller estates. Okay, and then the executor petitions to close the estate, and it's done. Sometimes it can happen pretty quickly. Other times it can go on for years, depending on what the issues are. Now, in many cases, the executor is not a lawyer. Okay, so in addition to there being an executor, there will be a lawyer representing the executor to make sure that the person does things correctly. The lawyer will see to it that all the proper documents are filed with the court, and et cetera, okay? On the last estate that I probated, one of the things the lawyer helped me out with was doing a search for unclaimed property in the state where the person died, okay? And that's a typical function of an executor. In this case, I wasn't an executor, I was actually an administrator. But in any event, my lawyer helped me do it. And in fact, we found something, I think it was $120 or whatever it was, when I applied for it. And I think we got the money. I don't recall. But in any event, so the thing about probate is it's costly, because there's going to be legal fees involved, court fees, filing fees, those kind of things. And it can be very time consuming, okay? So it can mean a significant delay in time for the heirs to get the property that the deceased person wants them to have. And so in many, many cases, probate is best avoided, okay? Now, I didn't give my regular disclaimer, but of course, I'm giving general information. Nothing I'm saying applies to your specific case. You need to, I recommend you speak to competent advisors to determine how you should handle your estate, or to determine how your estate will be handled once you pass away. Okay, so this is general information to help you understand some issues and have a more intelligent conversation with your advisors, your lawyer, your accountant, your financial advisors, et cetera. Okay, now, shoot, there was another point I was going to make about, so the most common way to avoid probate is to create a trust. Typically, it'll be a living trust, a revocable living trust, I should say. All right, we're not going to talk about that today. I've talked about that previously. I've talked about types of trust, revocable, irrevocable, those kind of things. So if you're interested in learning more about some basics of trusts, I invite you to go to our YouTube channel, youtube.com/@the-way-to-wow, and you can view those previous episodes. What I'm going to talk about for the rest of today's show are some other ways of avoiding probate, okay? And it may be if you don't have a whole lot of property, so these ways may be sufficient. Perhaps you don't need a trust. I say perhaps because, again, each situation has to be looked at separately. So while these may be useful tools for your situation, again, please talk to your advisors to get their input on your specific situation. Okay, so let's look now at how to avoid probate. Okay, so the first thing we're going to talk about is what's called a pay on death bank account, or what's sometimes known as a Totten trust. It's not literally a trust. I don't recall the way it became known as a Totten trust. You don't really hear that term that much anymore. Okay, now what a pay on death bank account does is just what it says. You have a bank account, and when you die, it's already been determined who's going to become the owner of that bank account. Now, when we say a bank account, it could be a checking account, a savings account, or even a CD, a bank CD account. Okay, so it's not limited to just a checking account. Okay, it could be really any kind of account held by a bank. Now, what'll happen is for the banks who will do this, you'll fill out a form, and I'm pretty sure you have to have witness the form, which means you go before a notary and you swear or affirm that you are indeed the person signing the document. Okay, now all that a pay on death bank account changes is what happens to the funds in the account once you die. Okay, during your lifetime, nothing changes. Okay, you maintain control of the account during your life. You can put money in, you can take money out. Okay, and in fact, you can change who gets the account when you die by filling out a new form. Okay, so you don't lose any control of your funds, and indeed you could close the account. Okay, and in that case it would essentially cancel the pay on death function, and that beneficiary wouldn't get anything because there's nothing for him to get. Okay, so one of the key things to remember about a pay on death bank account is you maintain control of the account during your lifetime. Now, there are a couple more things to know about it, and one is you may need to notify the beneficiary. Okay, some states require that in order for the pay on death function to, in essence, go live, meaning to be able to be exercised at your death. Okay, and the other thing to keep in mind is just because you've avoided probate doesn't mean that you avoid estate taxes. Okay, estate taxes are assessed on the gross value of your estate. Okay, that's the value of your estate, the value of all the assets in your estate. So just because the bank has a pay on death function on a particular account doesn't mean that they're immediately going to disperse those funds. They're probably going to make sure that they're not required to hold the funds in the event of estate taxes, and B, it does not exempt those funds from being calculated as part of the gross value of the estate in determining whether the estate has to pay taxes or not. Okay, so this is not how to avoid estate taxes. This is how to avoid probate. Those are not the same thing. Okay, all right, so that's one way to avoid probate. Let's look at the next one. Okay, so the next one is called a transfer on death account and deed, or I should have said accounts and deeds or account and deed, and whatever. Now, a transfer on death account, I'm going to deal with that first. Okay, typically you'll see this in a securities account, like a brokerage account. And in a transfer on death account, it's similar to the previous pay on death bank account, in that you fill out a form, and then upon your death, that directs who's going to get whatever is in that securities account. Okay, all the states have this except for Texas. Don't know why Texas doesn't have it, but it doesn't. That's just what my research showed. Okay, now, and by the way, transfer on death account securities is the most common area where you use this particular probate avoidance tactic. Now, a transfer on death deed relates to real estate. Okay, and you can see about half the states permit transfer on death deeds, including California and New York, which are two of the states with the most valuable real estate in them. Okay, and just like a transfer on death account, a transfer on death deed determins who gets a property outside of probate. Okay, so the real estate does not have to go through the probate process. All right. Another type of transfer on account deed, I put it in quotes because it's not, you don't deed a car, but it's sort of like that, is a car. Okay, so some states allow for a car to be transferred on death. I believe California has that provision, at least with respect to a spouse. So if a spouse dies, a car will automatically transfer to the surviving spouse. It doesn't need to go through probate, as long as the car is registered in California. Okay, I had a situation where a car was registered outside of California, and so when the owner of the car died, I had to go to that state in order to deal with the transfer of the car to his spouse. Okay. It's not like, if a car is owned in, Nevada, I can, and because California has a transfer on death function for spouses, I can't process a Nevada registered car here in California and say, I don't care what Nevada says, here in California, I can do it. It doesn't work that way. It's based on where the car is registered. Okay, and some states have that, less than half. I don't know the exact number, but it's something to check out. Again, especially if you have just a few assets, maybe you have a couple of bank accounts and a car. That's all you've got. You rented an apartment or a house or whatever, so you never own any real estate. It may be that you don't need a trust because you can do a transfer on death bank account. You can do a transfer on death account if you have a securities account, and you can just count on, your car being transferred on death as well. And so you don't have to worry about probate. Now, just like with a transfer on death bank account, transfer on death accounts and deeds do not necessarily exempt the property from estate taxes. The value of the property is going to be included in the gross value of the estate, okay? And that's what's going to be used to determine whether estate taxes are due or not, okay? So again, I want to emphasize this. This is not how to avoid estate taxes. It's how to avoid probate, that court process that can be costly and time consuming, okay? But it's not going to mean that the minute the person dies, you're going to be able to necessarily transfer these assets, even though a probate is not required. All it means is you're not going to have to go through the formal process of probate which will make things easier and faster and less costly. Okay, but there still can be delays while some of these other issues like estate taxes get worked out. Okay, now I talked about gift taxes, I think it was a couple of weeks ago. Right now, the exemption is close to $13 million. Okay, so you can see that for the vast majority of us, we're not going to have to worry about estate taxes, but that doesn't mean that just because an estate doesn't have to pay taxes doesn't mean they're exempt from filing a return. Right? This is the same thing with an income tax return. We may not owe any income tax. That doesn't exempt us from having to file an income tax return. We still have to do that. Okay. And so it may be the case that, the brokerage will hold off exercising the transfer on death until the estate tax return is filed, or until the final income tax return for the decedent is filed, so they can be assured that there's no estate taxes due, and they'll release the account to be transferred. Okay, that's going to be a policy issue of a particular brokerage company. Okay, so just work with them. Most, if not all of them, have special departments that deal with probate and estate matters. And if you call up the broker who is handling the account, if you're the executor or the administrator, you can and you can tell them, hey, I'm administrating, or I'm the executor for such and such person's estate. They may ask you for what are called your letters testamentary. That's the document from the court that verifies that indeed you are empowered to act for the estate. Okay. And they may ask you to send those to them or email them or whatever. Once they have those, then what they're probably going to do is say, contact the estate and probate department. They specialize in handling these things. And it will be much better, because the typical financial advisor doesn't have a lot of knowledge about probate and estate and trust matters, okay, because they don't deal with it that often. So you're better off dealing with a specialist, and then just, perhaps periodically touching base with the broker if necessary, to just, make sure you're doing your due diligence with respect to how the account is being handled. Okay, so a transfer on death account or a transfer on death deed, typically for securities, real estate, possibly cars. Okay, next. The final way to avoid probate that I'm going to talk about is called a joint tenancy with right of survivorship. You'll sometimes see it abbreviated you'll see the acronym JTWROS. Jate Ross or something like that. I don't know. I always see that, and it takes me a beat because it's such a conglomeration of letters. Okay, but it's a joint tenancy with right of survivorship. Now, as you might notice, because there's something called a tenancy by entirety that's only for married couples, that a joint tenancy, you don't have to be a married couple to enter into a joint tenancy, and that is correct. Now, some states don't even have tenancy by entirety anymore. In California, we have a joint tenancy. And a married couple can be joint tenants. They don't have to be. Here in California, I believe the presumption is they're holding property as community property, but a married couple can hold property as joint tenancy. Any two or more people can hold property in joint tenancy with right of survivorship. Now, real estate is the most common type of property to be held in joint tenancy. Okay, but you can hold a securities account as joint tenants as well. Okay, and there are other types of property that could fall in that, different excuse me, like two people could hold a partnership share as joint tenants if they wanted to. We can get into all kinds of complex things, but since our topic here is how to avoid probate, right, which we're trying to simplify things. So for most of us, again, the most common case where we're going to be a joint tenant is with real estate. Okay, it may be a house, it may be an investment property. It just depends on what it is. Okay. And the same is true for tenancy by entirety. I'm not going to refer to tenancy by entirety separately. It's the lesser common of the two, because there are states where it doesn't exist anymore. All right. Now, the thing about a joint tenancy is, let's say that two people own a property. Let's say two brothers own a property as joint tenants. They each own 50%. We're going to make it a real simple example. Okay. So they have a joint tenancy with right of survivorship. When the first of the two brothers dies, his share in that property will automatically go to the other brother. Okay. Outside of probate, no probate has to be done on that property. It's an automatic function. Okay. And so if for example, the brother who died put in his will that he wants his half of that property to go to his wife and children, it's not going to. The way the title to the property is held, what's called the vesting of the property as joint tenants of the two brothers, means that when one dies, the other one is automatically going to get the interest of the deceased joint tenant. Okay, so that's one issue. Another issue with a joint tenancy is once you've created a joint tenancy to own a property. Okay, let's say it's an apartment building. Once that apartment building is held by joint tenants, it cannot be dissolved by one joint tenant. The joint tenants have to collectively agree to alter the ownership structure or the vesting of that property. Okay, that's why I say you cannot unwind it without the other party's consent. Okay, because you're taking away a property right by unwinding that joint tenancy. Okay, once it's created, each joint tenant has what amounts to what's called a remainderment interest in the other joint tenant's interest. So that cannot be unilaterally taken away. Okay, so that's something to keep in mind, because unlike the previous two, the pay on death bank account and the pay on death account for securities, the person who owns the account retains complete control of them during their lifetime. It's only once they die that the pay on death function, can happen. Okay. With a joint tenancy, once the joint tenancy has been established, now the way the property is dealt with is changed. And so let's say you own a property as an individual, and you're dealing with your estate matters, and you decide, well, I think I'll set up a joint tenancy with me and my sibling, my sister or something. Okay. Once you set up that joint tenancy, you no longer have unilateral control of that property. You're going to need the consent of your fellow joint tenant in order to do certain things, okay, including sell the property. All right. Just like with the other ones, a joint tenancy with right of survivorship avoids probate, but it doesn't necessarily avoid estate taxation. Okay, I'll say it for the third time. This is how to avoid probate, not how to avoid estate taxes. So merely because a property transfers to a surviving joint tenant automatically doesn't mean that it's excluded from the gross value of the estate. Quite to the contrary, it is included. Okay, and so there may be some repercussions about that joint tenancy, or that right of survivorship transfer that is caused by estate taxes being due. If it was a $50 million property, let's say, so the fact that it'll transfer outside of probate is all good and well, but at $50 million, that estate is probably going to be subject to estate taxes. I say probably because, we'd have to know all of the individual particulars of the situation. Okay. And we'd also have to know then what provision was made for paying the estate taxes and all of that. That's why estate planning is so important. Okay. But again, just to emphasize this, the joint tenancy with right of survivorship, it will avoid the process of going through probate, but the property is still probably going to be included in the gross estate, the valuing of the gross estate. All right, so those are the three most common ways to avoid probate outside of a trust, typically a revocable living trust. That would be a fourth way that I've talked about before. These are alternatives to that. Okay, if you want to get help, here's how to get in touch with me. You'll see all of this in the show notes after the episode posts to our YouTube channel. And, here's the legal stuff. And let's go ahead and stop sharing because we're coming up at the end of our time. So just a couple things. I mentioned the YouTube channel. So, shameless plug. If you like the show and don't want to miss any episodes, then please do consider subscribing to our YouTube channel. It's real easy to do. Just go right on the channel. You'll see a button, subscribe, and click on it. And that way you'll never miss an episode. And speaking about episodes, so tomorrow, which is Independence Day, I have a special show and a special guest, a long-standing friend of mine by the name of Rabbi David Becker. He's an Army chaplain, and he is also the founder and director of an organization called JFAM, Jewish Friends of the American Military. And so on tomorrow's show, which is Business Lessons from the Military, we're going to be talking about how the military, how military people take care of their own. You may say, well, that's not a business lesson, but I think it's a lesson that we as business owners need to be more focused on these days. There's a greater expectation among especially our younger employees about how we're going to interact with them. And so I invite you to come at 11 a.m. Tuesday, Pacific time, 2 p.m. Eastern time. Join David and me. You can get a free ticket to the show on our Eventbrite page, or of course, you can watch us on social media as some of you are probably doing right now. And then on Wednesday is People Making Money. And that is at 12:30 p.m. Pacific, 3:30 p.m. Eastern. And got a show lined up for Wednesday, a great show lined up for Wednesday as well. I think you will enjoy it. It's on how to use LinkedIn to create relationships, professional relationships specifically. So I invite you to watch that as well. And then next week, we'll start it all over again at 10 a.m. Pacific time with Trusts and Estates Weekly. So I thank you very much for watching. I hope you found this useful. If you have any questions, comments, please do let me know. Drop your questions or comments into our various social media outlets, or shoot me an email, and I'm happy to help you. And that is it for today. So that just leaves me to say, as I always do in sign off, Marie, darling, you are my bell. Thank you all very much for watching. Enjoy the rest of your